really wants the property, they have to satisfy the lien first. However, there is a problem regarding setting a precedent. Sweet went back a couple of weeks later and asked them to punch up his case number. Guess what? The case number had disappeared. The reason the case number disappeared is that after the judge ruled the county owned the property, subject to the lien, it became a case that goes against the corporate county bankruptcy public policy. Since Sweet placed a lien on his own property, he is the one who has to be paid off first, not the county. The county is now required to satisfy the lien before the county is allowed to take possession of the property. The property is probably not worth the price of the lien. This would not satisfy the true creditors, the international banksters. If the county pays Sweet off first, the city has to put on their records a $75,000 deficit. The true creditors wouldn't like that deficit. They certainly wouldn't like the fact that Sweet's clever maneuver had outfoxed the foxes. What if 100, 200, 1,000, or 10,000 people in your state would just put a common law lien on their property and then stop paying taxes? Then cited Sweet's case, it would set a precedent. Let the county have the property as long as the judge makes the judgment subject to existing liens. In this situation, the county would end up holding all this property but could have no use of it. No rent, no taxes, no permits, all deficient. The bankster creditors certainly don't like this scenario. The banksters don't want any cases administered except through the application of bankruptcy procedure. The banksters want your rights, privileges, and due process strictly administered by and through the corporate courts under their corporate public policy. International bankruptcy procedure. The international banksters and their unregistered foreign agents don't want any evidence on the record, showing how you can get out from under them. Any revenue collecting individual or agency such as the courts, judges, lawyers, law enforcement officers, and tax collectors who are attempting to take money from you as a private American must be registered as a foreign agent. If they are not duly registered and properly identified, they are involved in extortion treason against private Americans. How Sweet it is. As part of Sweet's maneuver, he filled out a financing statement using the UCC 1 form, whereby he put his wife and himself as debtors and creditors. Now, the legal situation is switched. The UCC 1 financing record Sweet filed with the state shows Sweet and his wife as being the parties of interest recorded with the state rather than the presumption that the international banksters are the parties of interest. There is an office within each corporate state, Secretary of State, that handles the Uniform Commercial Code UCC 1 claim forms. Since Sweet is listed on corporate state records as debtor and the creditor on his own property, his property can't be put up in any way for collateral against any debts claimed by the banksters. The reason is that the international banksters and their flunky agents now cannot prove that Sweet's property is debt property of the bank or the corporate county. The property cannot be put up against any debt claims until it is not encumbered by Sweet's lien. Sweet's property is not free and clear of all liens. The result is that for all practical purposes, the property is now Sweet's, being unencumbered by any further demand for payment of taxes. Sweet has not paid property taxes for many years. Sweet is now his own creditor, and Sweet is his own debtor. Therefore, the international banksters along with the county corporate thieves are knocked out of the stealing process. How sweet it is. Congratulations to Mr. Sweet. You may want to do it the way Sweet did. If you own property, you will need to get your deed and a common law lien, then fill out a UCC 1 form, then file it with the Secretary of State. This seems to be the only way for you to get out from under being a debtor of these bastardly corporate foreign international banksters. The judges have to know what's going on. The only way this scheme can work is to have all the lawyers and judges pledge to uphold the corporate bankruptcy public policy. The banksters just can't allow lawyers in a legal system who refuse to uphold the bankster policy. These renegade lawyers would have to be quickly weeded out. They certainly have a neat little system going here in America, the land of the free and the home of the slave. Attention, law student, you said you wanted to be a lawyer. Well, I hope you're reading carefully, because here is the legal system you're headed to serve, and serve you will. You said you wanted to be a lawyer so you can find out what oath they're taking, in secret, behind closed doors in solemn preparation for the business of the court as judges and lawyers. Now, you know the oath. The oath is simply to uphold the bankruptcy. If you want to be a lawyer and want to make a living as a lawyer, I can tell you this. They will weed you out at the very beginning if you don't bring in your paperwork under the bankruptcy procedures. If you try to defend your clients and try to help your clients, they will get rid of you. They will pull your license. So you spent all that money and time going to school under the disguise of helping people, and you're wasting your time. Without that license you can't go into a courtroom. I would think about this. Traffic citation regarding the UCC 1 form. You can also file it against your car. Wouldn't that be a kick in the tail if you went into court for a traffic citation where you had signed without prejudice UCC 1-207, and you had dishonored the traffic citation using the UCC in your procedure by having signed without prejudice and having gone home and sent in your dishonor of the presentment of the traffic citation. Now, let's say you are in front of the judge. The judge says, "What's this dishonor stuff all about?" The judge will not want any mention that the citation was issued under bankruptcy. He is afraid you'll mention the bankruptcy issue. The reason you dishonored the traffic citation is that it was issued to you under bankruptcy corporate public policy. He won't get into that. When you get before the judge, you just state you have removed yourself from the bankruptcy. Tell him your auto is no longer pledged for collateral against the debt. He'll say, "Oh yeah, what are you talking about?" That's when you hand him the UCC 1 form that you filed with the state. This UCC 1 form will show that you are the debtor and the creditor on your auto. Now what happens? The corporate county state can't collect on the traffic citation debt instrument. Why? Because, not that you're the creditor on the ticket. If they collect a $100 fine, they have to pay you the amount of the fine. How sweet it is. You're the creditor, aren't you? People have done this. Of course, there is no record, no paper trail. In such cases it is not cited. The corporate banksters' agents, clerks, lawyers, judges etc. take the information out of the records as soon as you beat them at their own game. Here is what I think happens in these cases. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. The American Bar Association is not concerned primarily with what happens in any case on the local level. However, when a case leaves the local level, by that, I mean the state court, city court or the justice of the peace, or even the federal court, and goes to the appeals court, it would appear that the American Bar Association takes notice of the case. It would seem that the American Bar Association must have an agreement that any action brought on an appeal must be reviewed by the American Bar Association. If this is true, it would make sense. How else would the American Bar Association, a branch of the Lawyers Guild of Great Britain, which is the legal arm of the Rothschilds dynasty, be able to monitor and administrate the corporate bankruptcy? It would appear that the American Bar Association would be compelled to review all appeal cases and to make certain any case brought under common law or the constitutional law that would expose the bankruptcy would be immediately stamped on the back that this case is not to be cited or published. I believe that this is the stamp origin and purpose of the stamp message in such cases. The Justice Department may be able to do that in Washington, D.C. I can't see where any judge or lawyer could have the authority to stamp or label the case as one not to be cited for future cases. I think that is an official stamp from the American Bar Association. The bankruptcy accounting system now. Joe, law student, if you're still attending classes and you have a good professor, ask him her about just where the stamp comes from that you've seen on many cases. Just who put it on the paperwork and just who authorized the citation restriction. Just who is tampering with the law. There is one thing certain. The creditor and or his agents are watching these cases very carefully. The creditor and his agents must balance their books. When you think of the IRS, be aware that the IRS is an agent of the creditor, the corporate international banksters. This is just one of the banksters' stateside agencies. The General Accounting Office, GAO, is another agency they use for this country. This is where all the accounting goes to keep track of your lawyer's secret oath. What was the effect and the significance of the Erie v. Tompkins case decision of 1938? The significance is that since the Erie decision, no cases are allowed to be cited that are prior to 1939. There can be no mixing of the old law with the new law. The lawyers, who are members of the American Bar Association, were and are currently under and controlled by the Lawyers Guild of Great Britain, created, formed, and implemented the new bankruptcy law. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. Since the Erie v. Tompkins case was decided, the practice of law in this country was never again to be the same. It has been reported, source unknown to writer, that every lawyer in existence and every lawyer coming up has to take a secret oath to support the bankruptcy. This seems to make sense after you read about Mr. Sweet's case file disappearance discussed later in this report. There is more to it. Not only do they promise to support the bankruptcy, but the lawyers and judges also promise never to reveal who the true creditor party is in the bankruptcy proceedings. In court, there is never identification and appearance of the true character and principle of the proceedings. This is where you can get them for not making an appearance in court. If there is no appearance of the true party to the action, then there is no way the defendant is able to know the true nature and the cause of the action. You are never told the true nature and the cause of why you are in front of their court. The court is forbidden to tell you that information. That's why, if you question the true nature and cause, the judge will say, "It's not my job to tell you. You are not retaining me as an attorney and I can't give you legal advice from the bench. I suggest you hire a lawyer." The problem here is, if you hire a lawyer, who is pledged not to reveal the true nature and the cause, how will you ever find out the nature and the cause? You won't? Why? If the true nature and cause of the action against you is revealed, it will expose the real creditor from whom this action and cause came. In other words, they will have to name the true creditor. The true creditor will have to state the nature and the cause. The true creditor will have to say, "It's a bankruptcy proceeding." The true creditor would have to say, "I'm the creditor and he's the debtor." That declaration then opens the door for you to question, "Who the hell are you? How did you get attached to my back and by what vehicle did I promise to become a debtor to you?" In this country, the courts on every level from the justice of the peace level all the way up, even into the international law arena, called the World Court, are administrating the bankruptcy and are pledged not to reveal who the true creditors really are and how you personally became pledged as a party or participant to the corporate United States debt. What would really kill these people off would be to compel the international bankers to send a lawyer to the courtroom and present himself as the attorney for the true creditor, the international banksters, then have the attorney to put into the record the true nature and the cause of the proceedings against you on that particular day. The international banksters told these various countries that they were now in a state of bankruptcy. The countries had been taken over by the creditor bankers, and there was no choice but for all these participating countries to declare bankruptcy. If they didn't agree to declare bankruptcy, the banksters threatened to collapse the economies and thereby put the countries back into the depression like the one from which they were just emerging. The banksters made an offer they couldn't refuse. To review and elaborate, in 1930 there was a worldwide depression. The bankers said, "Look, you can do it either of two ways, the easy way or the hard way. You just accept the bankruptcy and we'll let you out of the depression. If you don't, you're on your own." So all the countries involved agreed, because they realized that the international banksters had them by the throat. The countries therefore agreed that over a period of several years they would pass statutes and legislation for the implantation of the bankruptcy in favor of the international banksters. Now, I would say that the key banksters were Rothschild and family and their agents by way of Rockefeller, by way of the Federal Reserve banksters, who were more specifically involved, as key banksters and their agents, is pure conjure on my part, but it really doesn't matter at this point. The point is, there was an international bankruptcy and an international conspiracy to cover it up. There was a banking creditor who made the offer. The countries accepted the offer in order to enable the representative countries to continue without revolution and to allow the politicians to remain comfortably in place. Under a delusion of solvency, the countries were allowed to continue to operate as though they were solvent, while in fact, the representative countries were bankrupt. The snare the bankruptcy scheme was as an extremely clever and diabolical plan. How did they possibly pull this scheme off in the area of real estate? The bankers did it with real estate, the same way they did it in the area of federal income taxes. These foreign banksters simply and deceptively devised ways and means to con you into declaring yourself as a citizen or a resident of the corporate U.S. Remember, the corporate United States is bankrupt per agreement and public policy. After you have been tricked into claiming you are one of their corporate United States citizens, you are given a social security number which ties you to certain meager benefits and privileges. Then, the banksters con your employer to function as an unpaid tax collector to con you into filling out their W-4 intangible property gift forms and 1,840 voluntary agreements. These slick paper agreements establish your voluntary indebtedness to the bankster creditor. If at any time you decide to balk at this scheme, because you don't like it. The real creditor never has to make an appearance in court to list the true nature and cause of the actions which is being brought against you. You end up dealing with an agency. The agency can conveniently grant itself immunity from prosecution because all it is doing, without your knowledge, of course, is administrating the bankruptcy, which the government agreed per the Geneva meetings. The court system never lets you put the original creditor on the courtroom stand, so you can ask him how he got attached to your back. The system is set up in such a way that the true creditor is protected and never has to make an appearance and never has to answer any of your questions or produce documents. Therefore, the true creditor never has to produce the law that gives him the right to pledge you, your body and labor, into indebtedness bandage servitude. Why? Because the Geneva Agreement in 1930 was done by treaty. The bankruptcy was not done by legislation. The agreement came first, signed in secrecy. Then Congress began to pass legislation to fulfill the bankruptcy obligation required by the treaty. Legislation being passed by Congress was henceforth and is thereby bankruptcy legislation. When cases came before the courts could make decisions based on the new controlling law of bankruptcy. It had nothing to do with constitutional rights. Now, any case brought in is under the new bankruptcy law and is not considered as a true constitutional case. It is now a bankruptcy case as distinct from, but cleverly disguised as a constitutional case. The members of the Supreme Court, of course, realized what was happening to them in the system of law. The court was being asked to perform in a creditor-debtor bankrupt proceeding to the benefit of the bankster creditors. The members of the Supreme Court said, "No, we will not give you a bankrupt proceeding decision that you can then enforce against everybody. A decision not only affecting corporate Washington, D.C. but also having effect within the corporate state governments. This, by the way, is fraud. It wouldn't be fraud if the government of corporate Washington, D.C. and the government of the several corporate states declared bankruptcy, then let the people know about the bankruptcy notice. When I say corporate government, I don't mean you and me. You and I are not the corporate government. The corporate government is the corporate capital of the corporate state. The government is a neutral government zone known as the corporate capital of the corporate state. The government is where the corporate state is. It is corporate headquarters. Just like corporate Washington, D.C. is the seat of the corporate federal government, the capital of the corporate state is the seat of the corporate state government. If the
3% of America whipping the British's ass and kicking them out of this country.
Hello, sir. I'm going to cut you some slack because this is a master class in law. This is not for the amateurs and for the first couple years that people study. Not blowing smoke up your ass, just blowing smoke. Everyone should take the day off and read the Treaty of Amity, Commerce, and Navigation. It's also known as the J Treaty. Now, this is especially relevant to all you fucks who keep asking me to help you fight traffic tickets. See, Article 15, that means this is Article 14. And it says, the people and inhabitants of the two countries respectively shall have liberty, freely and securely and without hindrance and molestation to come with their ships and cargoes to the lands, countries, cities, ports, places, and rivers within the dominion of the territories. We can travel freely, and they cannot molest us. They cannot hinder us. They can't give us tickets, and they can't tax us. So stop asking me to help and use the J Treaty in your defense. However, on another note, and I know this one strikes a nerve, but read it all. I'm not going to give you the cliff notes on this one, fact checkers, but stop taking this goddamn video down because it's true. We're still a British colony. We're still under English rule. The 4th of July is bullshit. It's a fraud. We are not independent. We are one of 13 colonies of England, Canada, Wales, Scotland, Ireland, Australia, New Zealand. Do I need to go on? We are one of the territories of England still. And this Jay Treaty was signed because there were 20,000 British ships that were cruising into Louisiana, and they were going to blow the shit out of the South, and they were going to kill them all. And the 3% that you speak of, sir, were not enough to stop them. And they signed this Treaty of Peace, conditionally, that they would go later and correct all the traits of what we could do in commerce. That's why the Jay Treaty is also known as the Treaty of Amity, friendship, commerce, and navigation. And you can use it in court to protect your rights, but we're not free yet. I think it's time we have Revolutionary War number 2 and kick these traitors that are in America acting as British agents. Yeah, okay, here's a fun one. Go read Title 8, Section 1481. When somebody signs their oath of office, they relinquish their U.S. citizenship and become a foreign agent. And the agents work for England. And that's a lot of the problems we're having today. They're not honoring this, the Treaty of Peace, nor the Constitution. And these double-crossers, and we call the British double-crossers because on their flag they advertise their double-crossers, the cross of St. Andrews and the cross of St. George. And they blended the two crosses to make their flag, telling the whole world they're double-crossers. And it's time we send them back across the pond and really kick their ass and really establish freedom, not just liberty. Have a safe and happy 4th of July, but know that it's with the bullshit. What? You're spreading disinformation? Just go there. Then go down to 21. The term national means a person owing permanent allegiance to a state. And then go to a local law library and read the holding of the Cherokee Nation versus the state of Georgia. They will show you in the laws of nations and in common parlance, the term nation is synonymous with state. That means I live in the country of California. I was born in the country of California, and I owe permanent allegiance to them. Federal law. Hey, Mr. AZ attorney, do you tell your clients that according to Corpus Juris Secundum 7, Section 4, attorney and client, that, what does it say here? Can you read? Thus, an attorney, what's that word? Occupies a dual position. His first duty is to the courts and the public, and not to his client. Do you tell your people that? I bet you don't. And I bet you, instead of someone going to jail for not paying child support? How many of those guys you convicted? Well, it's your turn. I bet you that all of your past clients can prosecute you for fraud, criminally and civilly. And I think it's time we do that with lawyers, LIARS, lawyers in America. I think it's time we put you guys in prison. You're betraying your own people for a price. See, your clients are being sold out by the judges. And I can get any child support arrears, child support current charges, case dismissed, equal protection under the law. And really all they have to do is watch all my videos and they'll get it in their head, but more is coming on that line. But see, we can get every case thrown out because you follow me. You don't though, do you? You should have blocked me before this, because now they're going to give me a community standards violation because I'm teaching people the truth about you traders. Your first duty's to the courts and the public and not to the client. Also, according to the Social Security Act, Title IV, Part D, Section 458, Incentive Payments to States, you, lawyer, prosecutor, and defendant lawyers, respondent and petitioner lawyers, and the judge, and the clerk of the court get, how do they call it? Incentive payments to states. And we're dissolving CPS and we're dissolving family court. It's going to be 50-50 from the gate. If you can't afford the child, surrender. If you don't want the child, waive your rights. Things are changing, and we're getting rid of people like you. You get paid by the federal government to keep us away from our children. You're definitely not American, because no American would do that to another American. Oh, it's in federal law that you're a traitor to the American people. Title 8, Section 1481, loss of nationality by native-born or naturalized citizen. You swore allegiance to a foreign corporation. When you took your oath to the bar, taking an oath or making an affirmation or other formal declaration of an allegiance to a foreign state or a political subdivision thereof, after having attained the age of 18 years. So, you swore to the British Accredited Registry your oath as an attorney or as a lawyer. Sorry, fact checkers, the facts are on my side. He did it to a foreign state. Ain't this nice, Mr. Fact Checkers? I'm giving you all the information here that you can easily verify everything I'm saying is true. That's the way I operate. I don't lie to my clients or my students. Federal law, Title 28, Section 3002, definitions, and then you scroll all the way down and you get to point 15, and it says the United States means a federal corporation. So all these states, cities, counties, all these subdivisions are agencies, departments. A department of the United States is the state of California. A department is Los Angeles County. A department is the city of Los Angeles. Get it? And an instrumentality of the United States, which is the police department for the city of Los Angeles, the Los Angeles County Sheriff's Department, They're all just corporations. See, according to the U.S. Supreme Court, 318 U.S. 363, Clearfield Trust Company versus United States, in order for government, because it descends to the level of a mere private corporation, whenever commercial paper, Federal Reserve notes, or securities, checks, are used. As such, they must be the holder in due course of a contract or other commercial agreement between it and the one upon whom specific demands for performance are made, like pay me money, pay me child support, go to jail if you don't. There must be a contract between the two parties. It must be signed by both parties. There must be a meeting of the minds. No man would sign away their rights. That would be an unconscionable contract. Slavery. And if at any time in the past they inadvertently waived their rights or lessened their status through contract, forgive them. You must. Because you can't force a man into something he doesn't want to do. So, all your games of, well, we'll get child support sooner or later, fuck you will. The Supreme Court already decided you pricks have to have a contract. And you don't. And here's another one of my favorite cases for you fact checkers. Rodriguez versus Ray Donovan. The United States Secretary of the Treasury? What? Oh my gosh. All laws, codes, rules, and regulations are for government agents only, not for the people. So you lawyers have been lying for a long fucking time. Go look it up. Read it. It's 769 F 2nd 1344. Did they teach you this in law school? Are you keeping the secret from all of your clients? Do you know that they're not going to prosecute you because you can go to a judge who's a member of the bar and they can say no? So you just do whatever the fuck you want? You guys are double crossers. You're fraudulent in everything you do. And me and people like me are putting an end to your bullshit. There can be no order for child support. 50-50 custody. Or I can waive my rights to the child. What? Women can get abortions and men don't get equal protection under the law? The right to not accept any responsibility for that child? That human being who they have to murder. But in our case, it's alive. And we still don't want anything to do with it. It's our right. Next. Oh, we'll see you guys at Nuremberg.